Hello and welcome to Let's Talk Law, the podcast where we break down the legal topics that matter most to you. I'm Greg Hall, and in today's episode we're diving into some of the most important yet often overlooked aspects of planning for the future: wills, lasting powers of attorney and probate. Whether you're just starting to think about getting your affairs in order or supporting a loved one through the process, understanding these areas can make a world of difference. I'm joined today by the Joint Head of Barwells Private Client Department, Solicitor and Director Stephen Ash, who will be shedding light on what you need to know, what to avoid, and how to make sure your wishes and your loved ones are properly protected. Thank you for joining me today, Stephen.
Thank you, Greg.
Yeah. Happy to do so. We'll go straight into the questions and we'll start with wills. And can I ask, what are the most common misconceptions people have about writing a will?
Most people think that making a will has to be really complicated, but it doesn't need to be. There was a recent study that said about 60% of UK adults don't have a valid will. So it's really important to make one, and even if you've got one, to then check it again as well regularly to make sure it's still up to date with your circumstances. A lot of people think that they don't need it, which shows in the statistics there. But we think that people do need it, and particularly when you have family or you have assets or you have children, that's the time that you really do need to have a will. Some people put off when they think that it might be really expensive, but again, it doesn't have to be. You can have a professionally drafted will here at Barwells from as little as £350 plus VAT.
Okay, and just to reiterate, what age or life stage should someone consider writing a will?
As soon as you're an adult. So if you have assets, or you have family, or if you have children, that's really the time that you need to think about doing a will.
What happens if someone dies and they don't have a will in place?
If you don't have a will in place and you pass away, then the intestacy rules will apply. So the intestacy rules are relatively complicated, and they decide what happens to your estate rather than you. And almost always they'll lead to unintended consequences. So people might inherit who you wouldn't necessarily want to inherit. So it's really important to make a will.
Okay, and how often should a will be reviewed, updated?
We normally say to people, have a look at your will every 3 to 5 years, but more importantly, when things happen. So those certain key life events, so birth, marriage, death in the family, changing job, retirement, moving home, someone going into care, all of those different things, lottery win, anything like that. Have a look at your will, go and see your solicitor, see if you need to update your will, or sometimes the will is fine, but it's the circumstances around the will, whether that's tax planning or anything else that might be relevant for you.
Okay. Can someone write their own will, and what are the risks involved if they do?
Yeah, so it's possible. So some people do write their own wills, and some people do it very well. There are risks involved. There's lots of pitfalls. There's really, really strict formalities about writing a will, about signing a will and how it's stored to make sure it's not damaged in any way. And any of those things go wrong, then it might be invalid. So it's really important to make a will. My advice is always to get a professionally drafted will, because homemade wills or shop bought wills don't always take account of your individual circumstances, so they can miss out key important information for you.
Thank you for that. We'll move on to LPAs, lasting powers of attorney, and to start with, what is a lasting power of attorney?
So lasting power of attorney replaced enduring powers of attorney in 2007. The old enduring powers of attorney only dealt with financial affairs, whereas the lasting powers of attorney, there are two types, one that deals with finances, one that deals with health. The important thing with a lasting power of attorney is different to the will. The will deals with things if you pass away. The power of attorney is whilst you're alive, but perhaps if you need a bit of help.
Okay. And what are the difference between health and welfare and property and financial affairs?
So the property and financial affairs power of attorney will deal with anything that you can do with your finances. So a property sale, paying bills, moving money around, withdrawing funds from a cash machine, any of those sorts of things. The health power of attorney deals with health decisions for you. So talking to doctors, talk to care providers, all of those sorts of things to do with your health. Without a power of attorney, then, and people often don't realise this, it might not be the people that you think would make decisions for you that are legally entitled to do it, whether that's a spouse or children. If you've lost mental capacity, it's only your attorneys that can make those decisions for you.
Okay, and regarding attorneys, who should you choose as an attorney, and what are the challenges with choosing that person?
It's a really important decision about who you're going to have as your attorneys. You can have up to 4 attorneys and 4 substitutes. You don't have to have that many, but the forms allow you to do so. It's really important to choose people that you trust. It is a huge position of trust, and it's really important to choose those people that you trust, because they're going to make decisions on your behalf if you're not able to. If you're having more than one attorney, it's important then to think about, do they get on? And the attorneys themselves, they'll have to sign the form when you apply to register the power of attorney, to sign up to the duties that they will have to act in your best interest all times.
Are there times when a lasting power of attorney can be challenged or overruled?
Yes, it can be challenged. That's normally if something's gone wrong, if there's some sort of financial abuse or something like that. They can be fully revoked in that situation, but that's pretty rare that happens. More often, someone will ask, can an attorney be removed? Perhaps there's been some sort of relationship breakdown or something like that. An attorney can be removed, but you can't add a new attorney. So at that point, you'd have to make a new one.
So what is the probate process, and how long does it usually take?
The probate process generally means the executors are appointed under a will, have to deal with the administration of the estate, and they will first of all identify the assets and liabilities of the estate, register the death of all of those companies, and get what we call the probate value, which is the value of the estate as at the date of death. That's the figure they'll need to then apply for a grant of probate and possibly pay inheritance tax on. Once they have the grant of probate, they'll be collecting in the assets of the estate, paying any debts, liabilities, paying the legacies that might be in the will before they pay the residuary beneficiaries. How long it takes really depends on what's involved and what the assets and liabilities are of the estate. And it's a very, very individual question. So for an estate where you need grant of probate, but perhaps don't have a property, then it will be a lot quicker. You might be looking at 3, 4, 6 months to complete the estate. With an estate that has a property, then it could be longer, but it really depends on how long the property takes to sell.
Okay, and are there situations where probate isn't required?
Yes, so quite often when you have a married couple, so on the first death, if that couple own all assets jointly, then the assets pass automatically to the joint owner, and then you don't need grant of probate in that situation. There's other situations where perhaps the assets are more modest, that the banks are happy to release the money without a grant of probate.
Okay, what are the responsibilities of the executor, and can someone turn down that role?
Yeah, absolutely. So the role of an executor, it's a huge honour to be asked to be an executor, but it comes with quite a lot of responsibility and liability. So the responsibilities are to deal with the administration of the estate in accordance with the law and to follow the terms of the will. They have to do so in a timely manner. They have to ensure things like taxes are paid, that the estate assets not diminished, or any unnecessary liabilities are incurred. It is possible if the executor doesn't want to fulfil their role when someone's passed away, perhaps through their own ill health, that they can renounce their role as an executor, and then it will be the other executors that will continue the role.
Can I ask, what is inheritance tax? When is it payable, and how much is it?
So inheritance tax is normally a tax that's payable when someone passes away. Inheritance tax, the rate is 40%, and it's payable above the inheritance tax allowance. So everyone has an individual allowance, which is £325,000. If you leave assets to a spouse, anything you leave to a spouse is free of inheritance tax, so there's no inheritance tax at that point. And if you have an estate where you're leaving, if you own a property and you're leaving that property to children, there's an additional allowance of £175,000. With a married couple who have children who own a property, maximum allowance on the second death then is £1 million. And if the value of the estate is above that, there's tax at 40%. But obviously it depends on the allowances that are available on your individual circumstances, whether you're married or not, or whether you've been widowed, whether you have children, whether you have a property.
Right.
Inheritance tax, some people call it an avoidable tax. Not always quite as simple as that, but inheritance tax planning goes back to at the time that you're making your will, taking some good advice to think, is there inheritance tax payable here? And if so, what can I do about that? And it's about early planning and generally falls into either spending, gifting or investing, taking advice about that to try and reduce the inheritance tax burden.
Thank you. What challenges or complications do you sometimes see during the probate process?
So probate by its nature happens when someone passes away, and often that's a loved one, a family member, and it comes at a really difficult time. You're suffering from a bereavement. And family tensions can be heightened. We sometimes see that. And it's really important to take some really good professional advice so you understand as the executor what your role is, what the order of events are, what you need to achieve. And we often find that having taken that advice, once you've got that clarity, that the families know what they need to do next, then that helps them through the grieving process as well.
How can someone make the probate process easier for their loved ones?
So it really goes back to where we started talking about making a will. If you have a valid will and you've reviewed it regularly, and so when the time comes that you pass away, that you've got a good will in place that's nice and clear, and ideally if you've got a nice list of assets and liabilities that's helpful for your executors to then administer your estate, that's a huge start.
That's great. Thank you ever so much.
Pleasure.
That brings us to the end of this episode of Let's Talk Law. A huge thank you to Stephen Ash for sharing his expertise, and to you for tuning in. If you'd like to find out more about anything we've discussed today, or to view all our legal services, please visit our website at www.barwells.com. Don't forget to subscribe to the channel so you never miss an episode. And if you found this helpful, please hit the like button and feel free to share it with someone who might benefit too. Until next time, thanks for watching and take care.